SJC-10992, Commonwealth versus Copeland.
Mr. Bateman, good morning.
Good morning. May it please the court. I'd like to begin by addressing the defendant's claims with respect to the opening and closing arguments, and then get into the more technical legal issues in the case. In the defendant's opening argument, in the Commonwealth's opening argument, the Commonwealth argued that the defendant had a specific plan to rob the defendant. To rob the victim, Mr. Marshall. At that point, there was no reasonable basis for arguing that he had a specific plan. All the Commonwealth had was a precipient witness that saw a fight in a parking lot and some partygoers the night before, one of whom said the defendant said he had no more money and they were out of crack.
How about the part that the defendant said to the people in the apartment when they were out of crack, that he made a call to arrange to go buy some crack. He decided to, when he didn't have any money at all with him in the light most favorable to the Commonwealth, he decided on his way to get the crack that he would bring a knife with him, that the victim was stabbed, that he came back from there with crack cocaine and blood all over it, and blood on him and money.
Let me try to answer as many parts of that as I can remember. First of all, again, remember the procedural posture of the case. The Commonwealth had the medical report of the defense experts, but they didn't know at that point that he took a knife from the apartment, for example. He testified he did that, but at the opening argument, the Commonwealth didn't. They obviously knew that someone was stabbed, but they didn't know he took the knife. And in terms of saying, I'm going to get more crack cocaine, he never said that. He never said that before he left. All he did was ask the lady to use her telephone. Now, I'm sure I didn't cover all the other aspects of that, but again, keep in mind, the Commonwealth really did not know what happened in that car. All they had was the woman who looked out the window and saw a fight in the parking lot. They didn't know how the guy was stabbed, any evidence of that there was a taking. Now, I'm sure that there's some other parts of every question, but
thank you.
But they didn't know that.
But I mean, you're focusing on the opening statement.
Yes.
But it sounds like you're really focusing on whether or not the judge erred in denying the motion for a required finding at the close of the Commonwealth's case.
Yes.
Because everything, as far as I can tell, the prosecutor said no more than what the prosecutor contended he or she had proven when the Commonwealth rested. So it's not, so let's focus on the issue of the sufficiency of the evidence at the time the Commonwealth closed. So they had the fact that there appeared to be a robbery. Are you saying they didn't have that?
They didn't have that either. They did not have evidence that anything was stolen from this man.
But what about the testimony of his friend that he talked to when he came back from sweating and covered in blood? He told Brown that he'd just robbed someone.
Well, he didn't say that.
He didn't?
He didn't say he just robbed someone.
Took care of business. He'd gotten someone and took care of business. And Brown took that to mean he'd robbed someone? No?
That was her interpretation. But in terms of an actual taking of a robbery, the Commonwealth didn't. There was no evidence of that there was no evidence of it ever in the case.
How about the three different stories he told the police about what happened as far as consciousness of guilt?
Absolute consciousness of guilt. He admitted it.
I mean, as it relates to what the prosecutor has in mind as to whether there was an inference that could be drawn that the crack cocaine was stolen as part of a plan.
Well, when he testified, and this is after the close of the Commonwealth's case.
But I know, and it's a very fair point. But in the Commonwealth's case, the defendant's 3 different stories to the
Right.
police came in, and they're not like sort of different. They're different.
There's certainly an inference of consciousness of guilt. I mean, those are facts in the record. But whether there's still constitutionally sufficient evidence that there was a robbery, and there was the Commonwealth's case turned on a syllogism. It turned on the syllogism that I'm out of crack, I got to go see my crack dealer. Supposedly I have no money, therefore I robbed the guy. And I came back, and supposedly I came back with crack, marijuana, and money. That's the forward-looking
Supposedly,
syllogism.
or did they say that they smoked crack after he returned?
They didn't smoke any crack after they returned.
Did anybody say that there was crack that he returned with?
Yes.
Okay, so.
Yes, she said, Shakira
they had
Brown
no,
said.
They had no crack. He used her cell phone to call somebody who he was going to go to get crack. A person is found dead outside, having been stabbed to death, and he comes back with crack.
And is that constitutionally sufficient evidence that he took something from someone? I would suggest that doesn't make it. I mean, we don't know. One of the questions that came out on cross-examination of Shakira Brown was, did you check his pockets? How do you know he didn't have any? How do you know he didn't have any crack? How do you know he didn't have any money? How do you know he didn't have any marijuana?
So that was all raised before the jury?
Yes. Yes.
And what's your best case that's comparable to the facts of your case that would support your argument?
In terms of precedent, I believe it's in my brief. It's Commonwealth versus Mandile. This has come up in the case law,
Yeah.
where a person returns with I think the line in the case was newfound wealth. But this whole thing turns on the fact, and again, I would say you got to keep in mind the procedural posture of the case. They didn't know what happened in the car. They didn't know what. I mean, the guy's wallet was found at the hospital. They don't know anything was taken from the wallet. Their whole case, Commonwealth's whole case turns on. Supposedly, he says, and he did. I mean, there's enough testimony about that. I don't have any more money to go buy any more crack. Basically, that's what was going on. They were sending out for crack constantly the night before. And then the next morning, he gets on the telephone. He borrows Shakira Brown's telephone, calls up his crack dealer, and arranges to meet. And by the way, he wanted to trade marijuana for crack, and the Commonwealth made a big deal out of that as well, saying, well, who trades marijuana for crack? And he argued, well, common sense suggests that doesn't happen. Well, I can, from other cases, I'm sure this court knows that the Commonwealth has many drug experts on the drug trade. And that is not beyond the realm of possibility, but he made a big point to that in his closing argument.
But I'm going back. So in terms of witnesses other than him, there was Officer Courtney, who he saw, who said that he appeared to have been in a fight.
Yes.
As he's walking back. And then Ms. Brown said he was covered with blood.
Right.
So he leaves to get crack. He comes back having apparently been in a fight, and he's covered with blood.
But that doesn't make out an armed robbery. That may make out a killing, a homicide, a manslaughter.
Well, but then when Brown mentioned to the defendant that the police were outside, he removed $300 worth of crack rocks, $28, and some marijuana. The crack and the $28 appeared to be crack and money he didn't have before he left.
Based on the presumption that he had no money before he left, based on that one statement the night before.
Well, the statement is that they ran out of crack and they didn't have any money.
That's the Commonwealth's argument. I would suggest that's not constitutionally sufficient.
Why?
Why? Because lots of people say they're at a party and have no money to go buy more drugs for the party goers.
But she said that he went out specifically to get more crack, because why would you get more crack if you had?
I don't believe she said that. Unless I'm misreading something. I don't believe she said that. She was half asleep when he asked for the telephone, or he had just gotten up. I don't think there was any explanation other than, I think the testimony, to my recollection, was, I need to borrow your phone. He never told her why he was borrowing the phone.
Okay, I have not read the transcript. I'm just looking at the Commonwealth's brief, and on the morning, the group ran out of crack and money to buy crack, and there are many references to transcript 3 between pages 82 and 87. I assume that's Brown's testimony.
It would be Shakira Brown, but the point is, if you read my brief, I do address that, and he did not tell her, and I believe in the record she specifically said he didn't tell her why he wanted the phone. There was nothing about, I'm going to get more crack. That's my recollection.
Okay, obviously we'll go back to look at the transcript.
Take a look at that, and please, that is addressed in my brief.
Okay, so the key issue then is basically what circumstantial evidence, again, he appears to have, in terms of the sufficiency of the evidence, his testimony markedly strengthens the Commonwealth's case, because he at least admits he was in a fight.
Yes. Oh, yes. He admits he stabbed them.
Okay, so that piece of it is taken care of by his own testimony,
right,
which is why I didn't really focus on this argument of focusing on what the Commonwealth had when the Commonwealth arrested, because the Commonwealth argument speaks about the totality of evidence at trial, and some share of it came from his testimony. So, but it sounds as if your strongest argument may not be compelling, but the strongest argument is that not so much at the close of all the evidence, but when the Commonwealth rested, the evidence was not sufficient to support a finding of felony murder.
That's why I've said you have to look at the procedural posture of the case and what the state of the evidence was at that point.
By the way, when you mentioned he said he left the apartment, and instead he also said to the police that he never left the apartment and somebody came and brought crack. And that goes to consciousness of guilt as it relates to everything that happened, including how he got the crack that had blood on it.
I don't know if I'd go that far, but one of the things he did say, and he was very clear on the record, I lied about everything to the police, and he did, and those are the facts. Those are the facts in the record. But in terms of was it premeditated murder? Was it
The jury found they did not come back with a premeditated verdict.
No, they didn't, and that's true.
So
the jury rejected that, but it's still important. Should have been directed. If the evidence wasn't there, it should have been directed out. And more than that, it at least gave some incentive for the jurors to come back with another homicide verdict. And it might have been a different situation if premeditated murder was out of the question.
So you're saying the evidence was insufficient to even put it in front of the jury?
Premeditated murder, yes.
And that had that not been on the verdict slip, and had they not been instructed on that, then they would have arguably then felony murder would have been the highest charge.
Correct.
So you're saying they would have wanted to do something lesser than
Correct.
that?
That's my argument regarding that.
Have we ever said that if the evidence is insufficient as to a count on which the defendant was found not guilty, that the judge's error in not directing it out causes us to overturn the otherwise valid conviction?
I don't know whether, to answer that specific, I don't know whether a murder conviction has ever been overturned on that, but I know there's at least one case, and I don't remember whether I cited in my brief, that talks about this setting up a compromise verdict.
But of course,
I addressed it.
We have no, assuming the evidence is sufficient to support a finding of first degree, and I'm going to ask you in a second as to what I don't understand your theory that he was entitled to a second degree felony murder instruction, but I'll ask you about that in a moment. But assuming the evidence was sufficient on felony murder, how can we possibly say the fact that the jury had before it and rejected the idea that it was premeditated has somehow affected their decision to find him guilty of felony murder?
All I'm saying, you're correct. All I'm saying is that it set up an incentive since they couldn't get, yet you had a dead victim and a jury hearing a murder case and leaving in premeditated murder, even if there was inadequate evidence of it, set up the incentive for a compromise. That's all I'm arguing.
I don't know that we've ever done that either, but it's not like if they didn't find him guilty of first-degree murder, their only choice was not guilty. There was a second degree, obviously, and there was also, I think, a manslaughter,
Yes,
wasn't
there
there?
was a manslaughter
So
instruction, yes.
so it's not the draconian choice of...
No, it's not, but again, you got to look at how this was framed to the jury. And it was framed to the jury by the Commonwealth from the beginning, I would suggest improperly. Right down with, he had to say, if you take a look, and it's quoted in, I believe it's quoted in both our briefs, this is a guy with dramatic flair. This is a guy with a specific plan. There wasn't evidence to support that. I don't think there was evidence at the close of the Commonwealth's case to support that. Anyway, that is the argument.
And the jury found that it fell short of proof beyond a reasonable doubt.
That's
So-
right. That's right. But then we switch over to...
But you still have to address Justice Slowey's issue that if your claim is, this is a compromise verdict, they always have the ability
That's
to
right.
compromise by
That's
dropping
right.
it to
But if it's
manslaughter.
that's correct. But if it's out of the picture, it's one less thing for the jury to focus on, and they could focus on the other aspects of the case, and potentially all the other things wrong, whether the defendant had the mens rea well, let me back up, because this was pre-Brown.
Okay.
So
okay.
this is
Let's
pre-Brown,
move-
so we don't.
Let's move on. I don't like your chances on that one, but.
I agree with you.
But in any event, let's focus on, you say that the judge erred in not giving a second-degree felony murder instruction for larceny, but I don't understand that.
Larceny from a person, that's correct.
Yeah, help me to understand
Sure.
what the evidence was that would have supported
Sure.
a finding of larceny but not armed robbery.
Right. The evidence that would support that was the lack of evidence of how any taking occurred, assuming that there was a taking. Okay? They did not know what went on in the car, okay, until the defendant testified. And the defendant asked for larceny from a person based on theft for marijuana, and I would suggest that the Commonwealth's brief is incorrect on this point. The paragraph after that, it was Justice Gaziano, it was the trial judge. He brought up, or I'm not sure it was him or the defense lawyer brought up the concept of two bags. In other words, the bag of cocaine being behind the plastic sandwich bag of marijuana. Okay, it is the argument for larceny from a person is that this victim may have never known that there was a taking, assuming there was a taking. And if he did not know that there was a taking, it would not be a robbery. Because the differentiating factor between robbery and larceny from a person is the victim's knowledge of the taking from his persons or presence.
But wasn't the marijuana supposedly the defendant's?
Yes,
So
it
how can he
was.
take his own marijuana?
But that's what the defendant argued.
Well,
But that's why it was.
how is there a larceny? Why would you be so? Why would he get the instruction?
He wanted the instruction just in case the plastic bag of the cocaine was in the hand at the same time. Which is another thing, intent to steal. He thought if a fair reading of the evidence is that the defendant thought he was grabbing his hand, taking back what was in his hand, which he thought was his marijuana. Maybe the cocaine was behind that. Now, the Commonwealth answered that by saying, well, this defendant denied taking anything.
Well, to
I see my
prevail, you'd
time
have
is-
to basically persuade us that a jury which could find a taking, because they couldn't have found felony murder without finding armed robbery, could potentially have found that it was larceny as opposed to armed robbery when the guy ends up stabbed to death.
Right, like I said, it could be, and that gets into the mental state. What was that goes into my 33E argument.
But can we just stop on the larceny from the person for a moment?
Sure.
It is a difficult issue for you to address Justice Budd's question, because it seems like if there's a larceny from the person, it's got to come from the defendant's testimony about the marijuana. And if you took the defendant's testimony from the marijuana, you got to show that taking of that marijuana was inherently dangerous or created a conscious disregard for human life, and that the death was a natural and probable consequence of taking that marijuana. So even putting aside Justice Budd's question about how you steal some, yours, how on these facts could you possibly have a larceny from the person's second degree?
The fact that the best argument is that the victim did not know anything was taken from him. And if he did not know anything was taken from him, then it has to be larceny from a person, assuming he took something. And I see my time is up. I would conclude by saying I'll rely on my brief, but I would ask the court to reverse the convictions based on insufficiency of the evidence, order a new trial, or please consider the 33E argument, which I put in my brief.
Okay, thank you.
Thank you.
Ms. Campbell, welcome back. 24 hours.
Good morning, and may it please the court, Julianne Campbell on behalf of the Commonwealth. I'm here today asking that this court affirm the defendant's conviction for first-degree murder, for which he was convicted under a theory of felony murder. Just if I could begin by clarifying a factual contention about the exchange with Ms. Brown. What happens, and my understanding of the transcript, is that the defendant asks to use Ms. Brown's phone, does not say, I don't believe he explains why he's asking to use the phone, but he does use his phone, Ms. Brown's phone, then subsequently goes and meets the victim. This encounter ensues where the victim dies. Then the defendant returns to the apartment where they had been using drugs and drinking all night. And at that point is when he hands over bloody marijuana, cocaine, and money, and makes the statements, I got someone, I took care of business. And so that's sort of the exchange as it relates to Ms. Brown from my reading of the transcript.
What is the evidence as to whether they had run out of crack?
So both Ms. Brown and Ms. Hinson testify throughout the trial that they had run out of drugs. There was also testimony and numerous times that they would run out of drugs during the course of the evening, go out and procure more drugs, but that by the time I believe it was when all was said and done, when they went to bed, they had run out of drugs, they had run out of money to buy drugs and could no longer get more drugs. It's the next day in the morning, I believe, that the defendant then asks to use Brown's phone, used Brown's phone to contact the victim, then proceeded to arm himself by his own testimony with a knife from the kitchen block. And
Can you stop there for a moment? What about your brother's argument that, as you say, it's by his own testimony, he armed himself? Attorney Maidman argues that in the opening statement that was not known to the prosecutor.
Sure, so if I could, and that is where I'd like to begin sort of the legal issues, is with the opening argument.
Opening statement?
I apologize. That would be accurate with the opening
Sorry.
statement. But the opening statement certainly did outline what the prosecutor expected to prove. And even if we take out the defendant's testimony that he armed himself with a knife, what the prosecutor did expect to prove and what did come out at trial, specifically from the Commonwealth's case, was that the defendant used another person's phone to arrange the meeting with the victim, John Marshall, that he went to the meeting alone. He left the two people he had been with all night and went to this meeting alone. He then, he had no money or drugs with him when he went to the meeting. He then had this encounter with the defendant, I apologize, with the victim, who ultimately was stabbed. Whether or not the prosecutor knew where the knife came from, there was certainly testimony in the Commonwealth's case that the cause of death was a fatal stab wound, as well as other, I believe, more superficial stab wounds. The testimony then came out that the defendant returned to the apartment after witnesses saw him engaged in a scuffle, after witnesses saw him walking away from the motionless victim, that the defendant then returned to the apartment. He sort of avoided responding. I believe it was Officer Courtney who may have reached out and at least saw the defendant. I believe she testified that she had asked or called out to him and he didn't really respond, but that's my memory of the transcript. I don't have the site in front of me. That came out during the Commonwealth's case in chief. The defendant then went to the apartment where, in the Commonwealth's case in chief, Brown testified that he said, "I got someone, I took care of business," and handed over the bloody money, drugs, and crack cocaine. So I think from that perspective, that evidence did come out. I think that supports the prosecutor's contention during the Commonwealth's opening that the evidence he expected to prove would prove first-degree murder, premeditated murder, as well as an armed robbery and felony murder. With respect to the Commonwealth's closing, the defendant did make several claims in his brief.
I'll tell you the one that concerns me.
Sure.
And it's the expert. It's the issue, I can't remember the precise words, but the expert, he's got a job to do to come up with an excuse and then sell it to you, something like that.
Sure.
I don't know, I find that a little bit concerning.
So, and what I would say, I have two main points about that part of the prosecutor's closing. First, I believe the prosecutor's closing was about 19 pages. There was about 2 paragraphs about the expert. Much of what the prosecutor did say, aside from that specific language, was commenting on what the expert himself testified to, which is that he was paid for his testimony, that he did listen to the defendant with a sympathetic ear, that he did not independently corroborate other avenues of corroboration available to him. He simply took the defendant's word at face value in many respects. The prosecutor pointed to all of that trial testimony, I believe, either prior to or in conjunction with that statement. I would suggest first that statement may have been enthusiastic rhetoric and hyperbole that came very close to the line, but I do think that it was rooted in the testimony that came out of the expert's own mouth at trial. But more than that, what I think is very important about this issue is that what the role of the expert's testimony was and how it relates, in fact, to the verdict and the defendant's theory at trial. And what that expert testified to was essentially that the defendant was hypervigilant because of PTSD-related symptoms, and that would explain why he was more susceptible to being concerned about being controlled. It was the defendant's testimony that said, "I felt controlled, I felt I had to threaten him with a knife, and then it escalated, and I ultimately stabbed him." But what's important about that is that the jury rejected the premeditated murder argument, and the defendant's claim of self-defense, as it's supported by this expert, relates to the first-degree premeditated argument. The jury did not convict him of that. They convicted him of armed robbery and felony murder, and I think that that's important as it relates to this case because self-defense, generally speaking, is not an avenue of defense for an armed robbery. And I would point the court's attention, I apologize, to Commonwealth v. Rogers, 459 Mass 249 at page 260. It's a 2011 case that I think stands for that proposition. And so in that way, even if this court were to conclude that the prosecutor's statement perhaps crossed the line of enthusiastic rhetoric, given the posture of this case, where the jury acquitted the defendant of premeditated murder, I don't think that rises to a substantial likelihood of a miscarriage of justice in this case, which it's an unpreserved error, and that's how this court should review it.
Was there any weapon found on the victim?
I don't believe a victim was, I apologize, a knife was recovered on scene. I don't believe.
Well, the knife that was used in the killing, I gather.
I don't believe any weapons were recovered on scene. I apologize.
The knife's in a friend's? No. That's the what was in the closet of the friend's house that had the DNA?
There was a bag of clothing, I believe, because the defendant had showered and then put his clothes in a bag.
I have one more question, please, about the expert. And I take your point. If the relevance of the expert testimony was going to lack capacity to formulate the necessary intent for deliberate premeditation, then I hear you. But just as an issue of expert testimony and what the expert has to do about other possible scenarios out there, isn't it permissible for the expert to hear the defendant's view of what happened? And assuming that view is true, without investigating or addressing credibility, assuming that view is true, to give the jury an opinion based on that testimony?
I think it would be, but I also think it would be proper for, in this case, a prosecutor, but an opposing party, to question what the basis of that opinion was. And if the basis of that opinion was based exclusively on one version of events that they heard, when there were other avenues to corroborate, I think that that's a proper format for cross-examination.
I do too. The concern I have, and again, maybe I shouldn't spend too much time on it if you're right, but the concern I have is that the prosecutor was impugning the expert, not saying, not trying to say that the expert didn't look at these other possibilities, so you should consider the credibility of the expert and take that into account. It's more than the closing was impugning the expert. He's with the excuse argument and selling you an excuse. And that's different than in a pointed, appropriate way saying that the expert only looked at this from the perspective of the defendant, so you should give it less credit.
And I understand Your Honor's point, and I think what I would say is that the prosecutor in many respects did explicitly highlight what I think you're suggesting was proper, which is that he didn't consult other sources. And if anything, I think it's the language of he was paid and he came in and testified. I understand the court's concern about that. I do think the other commentary on what the testimony was entirely appropriate, insofar as it does go to highlighting the expert's credibility. But I hear the court's concern as it relates to, again, what I would suggest is enthusiastic rhetoric that was rooted in the evidence, but I understand the point being made of it possibly crossing
My
the
memory
line.
is there was no objection, is
That's
that correct?
correct.
And then so there's no, how was the jury instructed on how to handle an expert witness's testimony?
I believe there was an instruction regarding experts given. I don't have the site,
Okay.
but I'm confident that it was given from my memory of the transcript. And I also know that the standard instruction was read by Justice Gaziano as it relates to what closings are, what openings are, that they're not evidence, that they're the party's view. And the jury is certainly presumed to follow those instructions. And so I do think, to the extent that there was any error in the prosecutor's closing, the instructions as read were proper and did cure any error, at least as it relates, like I said, to a substantial likelihood of a miscarriage of justice. There were several other claims. I'm happy to go through those, or I only have a bit of time left. I'm also happy to address the sufficiency claims if the court would prefer.
Yeah, you said earlier that there was evidence, again, not from him, but that there was no money and no drugs. Was there evidence as to no money?
That's correct. I believe it was both Ms. Brown and Ms. Hinson's testimony that they had no drugs or money. And I think that was rooted in the notion that there is testimony that at several points throughout the evening, the group ran out of drugs, but were able to procure more drugs. And it was when they ran out of money, when they ran out of drugs, that it was sort of called a night.
Could you please address the felony murder in the second degree?
So my understanding is the only theory for the larceny from a person claim was that the defendant argued the marijuana was taken. And I think it was the Commonwealth and the trial judge's position that, well, it doesn't constitute a larceny if you're taking back your own property. And my reading of the transcript was that was the only the only proffered reason for that instruction. I don't think that there is an error in that decision, because legally you can't be charged or convicted of larceny if you're taking back your own property. It's your property. It's not the property of another. I also think that it doesn't make much logical sense to me that the evidence would be insufficient as to armed robbery because someone did not know property was taken, but it could be sufficient for larceny.
So if in the light most favorable to the defendant, there's a way to say that this marijuana didn't belong to the victim. Is there any way in the evidence in the light most favorable to the defendant that you could say that the taking of the marijuana from his person would be done in an inherently dangerous manner and conscious disregard for human life in the way that the defendant testified?
Here, well, what I would point to is that the marijuana with the crack is covered in blood. And so when you, I'm not sure I fully understand the question.
So it's not enough that it was, that there was a larceny from the person, which is not a life felony. That doesn't get you a second degree. Just because there's a possibility that there was a felony that doesn't carry life doesn't mean you get a second degree felony murder. You have to show that whatever that felony was executed in a way that was inherently dangerous, constituted conscious disregard for human life, and it was a probable consequence of that type of felony that someone would die.
That was never raised at trial. That argument was never made at trial. It was not raised at trial by the defendant.
Was it raised by the evidence that the defendant testified to in any way?
I would suggest it was not. Not in the light most favorable to the defendant, not consistent with his defense, and not consistent with his own testimony.
All right, thank you.
Unless this court has further questions, I would ask the court to not exercise its authority under 33E review as well, because I do think that the verdict here is consonant with justice. Thank you.